Regular Town Council meeting Thursday, March 30th, 2023, 9 a.m.
And all in favor?
Aye.
All right, thank you. We'll move on to item 3, presentations and proclamations. My understanding is there was a question about presentations and proclamations and how they get on the agenda. Generally, here's how it works. They're mostly historical. If somebody before has asked us for a proclamation for Problem Gambling Awareness Month, we tend to put it on the agenda so long as it's consistent with the values of our community and our town. So problem gambling, nutrition for older Americans, and water conservation are things I think we all in the town support. So that's the history of how these things get on here. No more mystery than that. Is there anyone from Problem Gambling Awareness Month here today to receive the proclamation? If there isn't, I'll ask for a motion to dispense with the reading of the proclamation and just go directly to approval.
So moved. Second.
And all in favor?
Aye.
Same with item B. Is there any representative of Older Americans Nutrition Act program here? All right, I'll ask for a motion to dispense with the reading of the proclamation and go straight to approval.
So moved.
Second.
All in favor?
Aye.
Item C, proclamation for Water Conservation Month. Is anybody from Water Conservation Month here? No? All right, so I'll ask again for a motion to dispense with the reading and go right to approval.
So moved.
Second.
All in favor?
Aye.
All right, thank you so much. At this point, we ask for comments from the public regarding the agenda items. These are not items, again, that don't appear on the agenda. That goes to the end of the meeting when we invite the public to talk. Are there any comments on items that appear on the agenda from the public? All right, seeing none, we'll move over to the consent agenda. Is there a motion to approve the consent agenda?
Mr. Mayor,
Yes.
I'd like to pull item E, Beachcomber Stairs change order for discussion, please.
Okay. All right, is there a motion to approve the consent agenda as amended with item E pulled?
So moved.
Second.
All in favor?
Aye.
Okay, let's take up item 5E now. Councilman Elwood.
Okay. A couple questions arise when I look at this. First of all, it states for folks in the public, we had a delay in completing the contract along the beach, which pushed us beyond February 28th, so we had to get a permit extension from DEP, and the cost of the service was $1,500. Is the contractor responsible for paying that, given that they could not complete the contract on time?
No, and I would indicate that the issue was not finite relative to the contractor not being able to complete on time. It was a combination of timing, in other words, our ability to get the drawings done, and it was not so much related to the contractor as it was simply the clock ticking on February 28th.
Okay. And my second question, how much work is involved for a $1,500 fee? How big is the form? You know, what's involved? It kind of struck me as not being cheap, let's put it that way.
I could have Mr. Boning here reach out individually or collectively with the more specific, narrow details on his communication and contact to get that done. However, I know generally there is simply documentation that he has to provide as well as communications with DEP to indicate essentially this is the scenario. They provide the relative details that have not changed, i.e. the location, the type of work, and it really was just a matter of communicating that particular piece, which was not to say our delay, but the generalized delay because of the clock ticking.
Okay. Well, I presume we've already paid them for that service.
I'd have to check to see if that was
okay.
already completed.
Maybe, I don't know about the rest of the council. I would just like to see the paperwork they filed. If it could
Sure, yeah,
be sent to me. Thank you.
All right, that being said, is there a motion to approve consent agenda item 5E, which was pulled?
So moved. Second.
All in favor?
Aye.
All right, thank you for your comments, Councilman Elwater. We'll move now to the mayor's report. I don't have a lot today. I just wanted to make a comment on traffic on A1A. We seem to have had a triple whammy. A lot of people down here. We've got some work being done on some utility poles, and we had a spirited discussion with the county's representative in terms of changing the timing on the light, which I think has shown some improvement. I know that we tend to see a decrease in the traffic backup and the issues as we get past the season. I think it was very helpful, and thank you for town staff for encouraging our residents to reach out to our County Commissioner Moss, who is the responsible point person to discuss with the Public Works Department the changing of the light, because the town directly working with the County Public Works was not getting very much cooperation. So we'll continue to monitor that, and hopefully we'll see that situation continue to improve. On the water issue, the town attorney will bring us up to date briefly on where we are, but we have what we call the rate case on appeal. Tuesday will be those of us who are traveling down separately because of sunshine law restrictions. Not very good for gas consumption, but that's the way it is. We'll be traveling down for the oral argument. Just for the public's benefit, we do not expect a decision will be coming from the bench. Usually it takes some time for the court to take the arguments under advisement and then issue a ruling. We will have to see, based upon the reaction from the bench, what we do in terms of the more recent rate increase and how it affects the franchise agreement and the timing, if any, of legal action, additional legal action that we will take against the city of Vero Beach to protect our ratepayers and our citizens from not getting the benefit of a franchise agreement that predecessors of ours negotiated in good faith. Last up, just an item to observe in today's paper. You may have noticed that Sebastian is having some issues with consummating its trash agreement as well. Again, this is not to make any of us feel any better, but it doesn't make us feel any worse, particularly Mr. Corpar, since we're all in this together. Unfortunately, there's just an industry-wide disruption, and we're doing the best we can. I think matters have stabilized since last month when we had representatives of Republic here. For what it's worth, nothing's perfect, including their service, but I think from my perspective, the complaints have gone down dramatically. Nobody's been knocking on the door or sending me texts or giving me phone calls complaining about terrible service. So I think we should give credit where credit's due, and I think they've made an effort to try to improve the service that they're providing to us. Last item, an important one for council, dress code. I looked at the long-range forecast. It's going to be pretty warm toward the end of April. So without objection, I think we can go to summer dress code beginning with the April meeting. Are there any objections?
Shorts and flip-flops?
Shorts and flip-flops, but and a tie. If you wear shorts, you have to wear the Bermuda-like socks. All right, without objection, we'll move on to that. Councilmember Alwater has an item on the prohibition on open primaries and nonpartisan elections, which is a joint resolution before the Florida legislature. Councilman Alwater.
Okay, I was alerted to this at a meeting, the Treasure Coast Regional League of Cities. They had a luncheon that was up in Fellsmere the other day, and Councilman Dodd from Sebastian raised this. This is the first time I heard about this. So what this is a proposal it's in the House, it's a joint resolution which proposes amendments to state constitution to provide that only qualified electors with same party affiliation as candidate for office may vote in primary elections for such office, to provide that candidates for office may not be prohibited from disclosing party affiliation or qualifying office based on party affiliation, and importantly, to prohibit exclusively nonpartisan elections. So right now here in the town of Indian River Shores, we have one election. The interpretation that I have heard, and if our town attorney has heard differently, I would certainly like to hear from him, is that basically it could potentially force us every time we have a council election to have two elections, a primary and a general. Now, it turned out, at least as I understand it, that if we had 5 people or well, we don't have 5 at one time. If we have 3 people running for 3, and they're all Republicans or all Democrats, and then you have the primary, then you don't have to have the general election if you don't have a person from the other party or independent. It's just a total waste of taxpayer money. And I think this is a reaction to what is going on in the school board elections, which have gotten really nasty, really ugly. So I put the full resolution in and, you know, highlighted some different things, but that's it sort of in a nutshell. Now, I've heard a couple of people say, well, this doesn't have a chance of getting through. I've been here long enough dealing with Tallahassee to find out that maybe the first time a dumb idea doesn't get through in the first go-round, but it oftentimes will get it through on the second or third. I think about the tree trimming restrictions on us prohibiting that and so forth. Everybody told me that wasn't going to happen, and it eventually did, and other things of that nature. What I would suggest to council is that we have a joint letter from the 5 of us just really pushing back against this. Personally, I don't have a problem with disclosing my party affiliation and having a discussion with Leslie Swan on this, who, believe it or not, wasn't aware of it when I met with her in her office on Monday. Anybody can call up the supervisor of elections and ask what my party affiliation is, the public record. So I don't have any issue with that, but the idea of having to have a primary and a general election, I think, is just a waste of taxpayer money. So I'd be interested in other folks' thoughts.
And just to put it in context, the joint resolution does not compel the result. It puts it on the ballot for the voters to decide as a constitutional amendment. We may have different information, but my information was that this is a priority for the leadership, and it has more than a reasonable chance of actually getting approved. But then the voters decide. So I'm comfortable that voters make the right decisions. So if this were a bill to just go forward with it and eliminate nonpartisan municipal elections, I may have a different opinion about us weighing in on it, but I have a hard time objecting to letting the voters of the state of Florida make a determination as to whether or not their election should be partisan or not partisan. As a practical matter, you're right. What it does is, in communities where you have a potentially partisan election between 2 parties or a non-party affiliate, you're going to have 2 elections. It doesn't have much of an impact on our town. We rarely have elections. I think Sam and I are the only ones here who actually went through an election, which was an interesting experience. So I don't think on our level it's going to have that big an impact as it relates to the town. Clearly there's an impact on school board elections. They've become partisan, not just here, but throughout the country. And lastly, what I call the fiction that the nonpartisan elections in Florida are nonpartisan is just that. It's a fiction. Voter registration is public record in Florida, and I don't know about the rest of you, but before I vote for somebody, I look up the candidate, I see who they donated to on the national scene, and I also look at their political affiliation. So I think the League of Cities, Councilmember Alwater, has done a yeoman's job of presenting the issues to the legislature, and I'm comfortable that they've been a sufficient advocate on this for us, so I would not be in favor of the town weighing in on this issue. So I'm fair to open that up for discussion to other
And you said the League of Cities has pushed back on this?
Yes.
I listened to the morning call each Monday morning. I don't recall them even bringing this.
Yeah, the advocacy group has pushed back on it.
Okay, all right.
And so the advocacy group, for the benefit of all these people, are selected representatives from municipalities throughout the state that when the frenetic activity in Tallahassee occurs, whether it be on this or any other issues, they then knock on doors and make calls to representatives. So this has been on their radar screen. how much they've pushed back may be a function of how effective they think pushing back is going to be if this is going to move through. I'd encourage all of us to weigh in individually on this issue, to our representatives, Robert Brackett and Aaron Grawl, our state senator, and even Debbie Mayfield, who has a historic relationship with us. But I think as a practical matter, it's probably a little too late for it to have any impact. And that's my piece on it. Is there further discussion on this requested by council?
I don't understand, Bob, maybe you can help me out. The language in the joint resolution that says can't be prohibited from provide that the candidate for office may not be prohibited from disclosing party affiliation. I don't understand how does that work? What's that mean?
When you, if I may,
Yeah, sure, go ahead.
when you're running a municipal election, and this is why we have a town attorney here to say, you're exactly right, Mr. Mayor, except for everything you just said. But in a municipal election, you don't run as a Republican or a Democrat. You can't put it on your campaign literature. You know, you're running as a candidate for the town council of the town of Indian River Shores. Is that basically it?
Yes, Mr. Mayor, just a couple to answer Councilman Orders and also to follow up on that. So number one, there are a couple of currently required nonpartisan elections. The school board, as mentioned, is one of them. Judges, circuit judges are not allowed to be party affiliated when they're running. As far as being on their signs, on their advertisement, on their campaign literature, they're all nonpartisan. That's all currently dictated at the highest levels. As far as moving forward with a joint resolution, that is the only way that, and this would require a change to the Florida Constitution. The only way that the legislature can propose it is, as the mayor said, having a joint resolution. The joint resolution would require, and I apologize, I want to make sure,
60%.
Well, to get out and to the governor would require 3/5 of both houses. And as far as I understand in tracking this, it looks like the last action was a House reading on March 7th. So it's a little bit, sitting right now. There is still roughly a month left, a little over. The beginning of May will be the last week of session. So we'll be monitoring it. But to the mayor's point and to the question, there are certain races that you're prohibited from putting on your advertising or otherwise saying, I'm a Republican running for circuit judge or something like that.
Got it.
It's not to suggest that people don't know that you previously voted as a Republican, registered as a Democrat, whatever. It's just you cannot affiliate yourself in the campaign. Hopefully that answers the question.
Anything else? Okay. Mrs. Gundy sent me a very eloquent email, and I just wanted to once again thank you for engaging on these issues all the time. It's always a pleasure to hear from anyone in the public. But you mentioned the provision for voting in terms of 5 points for this candidate, 4 points for that candidate, otherwise known as a jungle primary. So that would take a state constitutional amendment in order to do that. So yeah, so it's I think the real fight, if this passes as a joint resolution, is when it goes on the ballot. There is a supermajority available to the sponsors of this bill, should they decide to push it. But the real fight, I think, will begin when it goes on the ballot for a constitutional amendment. But
I think you all agree that it's making it more limited rather than less limited in terms of voter choice.
yeah, I mean, there's no question that if you can't vote for a candidate of either party or somebody who's non-party affiliated, that your choice is definitely reduced. No question. Yeah. Yeah.
Mr. Mayor, if I
Yes.
just briefly, in our charter, I just want to advise council, elections are governed by our charter, and our charter provision specifically says that our election are regular elections, so we don't have primaries, and candidates are based on a plurality of the votes cast for the office seat. So again, we already default to a plurality at a general election. It's how we would do our selection.
Right.
Thank you, sir.
Thank you. Anything else? Thank you for bringing this up. It's a very erudite discussion to have on a Thursday morning, but I think your point's well taken. That you see these ideas kind of percolate, and you have to watch them. And look what happened to the bill that Pete's going to talk about on water regulation. I think I was actually properly quoted You know, they started out with a horse and it looks like we're going to get a camel. Maybe a camel with 4 eyes, but, all right. If there's nothing else on this, let's move on to item 8A, discussion with possible or probable action. Item 8A, the audited financial statements. Welcome back.
Good morning. I'm Christine Olran. I'm the auditor at Carr Riggs and Ingram, the partner that oversaw your audit for this past year. So you all received the 2022 financial statements, so they're as of September 30th. You did receive a clean audit opinion this year. It looks a little different because our auditing standards changed, so the opinion's now at the very top of the first page. You don't have to flip back through anymore to find it. This past year, you had to implement the new accounting standard for leases. So now every lease that's over 12 months old, you have to record the asset and the liability. So it basically changes everything to what used to be a capital lease. And if you are the lessor, you now have to record a lease receivable and a deferred inflow for all the future payments. So your cell phone tower lease was already prepaid, so all you had was a movement in your liability to a deferred inflow on that because you've already received the cash. Your general fund did have a positive increase in your fund balance of $51,000, and the Governmental Finance Officers Association recommends having at least 3 months of unassigned fund balance to cover your expenses, and you have approximately 8.5 months in your unassigned fund balance, so you have very healthy reserves. You do have a new ARPA fund this year, so that was the grant that you received for the federal government. You utilized $729,000 of that grant, and you still have $1.3 million left remaining. So you have till the end of 2024 to obligate, and then to the end of 2026 to spend. The town strategically stayed under $750,000, so you didn't need an additional audit over your grants. So if you spend $750,000 in 1 year of federal grant funds, you need a single audit. So they stayed under that to save the town some money. Your non-major funds did utilize some of your fund balance. That was planned in your budget as your building fund needed to use some of the fund balance in order to stay in compliance with Florida statute. Your fiduciary funds did have declines in fund balance due to unrealized market losses, but in terms of funding, your general fund is still 107% funded, public safety is at 92% funded, and your OPEB's at 133% funded. For comparison, the Florida retirement system is only 83% funded. So you're very well funded in your retirement
Plus, they
plan.
use a higher
Yeah,
rate of return.
they do, yes.
What's the funding rate for the state of Florida?
It was at 6 point,
No, I'm sorry, the percentage of,
oh, they're 83% funded.
83? Thank you.
We did not have any findings or areas for improvement at all with Heather this year. She does an excellent job. She prepares all the statements herself. In terms of new standards for next year, it's referred to, the acronym is SEBITA's, Subscription-Based Information Technology Agreements. So any IT software that you use, you'll have to book a group of assets for subscription-based assets and a liability for the future payments. So it's similar to leases, but instead of just being physical things that you are leasing, we're now including software as well. We went through in a lot more detail with the Finance Committee last week, but if anybody has any questions at all about the statements, I'd be happy to answer them.
Are there any questions from council?
A question with some comments?
Sure, by all means.
All right. Just want to point out a couple things here. If you go to, in the lower right corner, which would be the page number, the entire packet, page 63, it has the changes in the public safety pension fund, and it shows the employee contribution was $98,000, and they got from us on the 175 plan, $144,000. It's in the additions up top. You see employee. So once again, as occurred in a number of years, the contribution that the public safety employees got from the 175, 185 plan was greater than their total contributions. So I just want to point that out. That comes up every once in a while. On page 81, who is our line of credit with currently? South State. Okay. And you feel they have the capability to do that if, God forbid, we get into a situation where there might be a problem? Oh, okay, all right. Just one last thing. Do you have a sense of, in terms of property tax revenues that are paid to the county by taxpayers inside Indian River Shores, what percent of the total that represents? Or could there be a way for you to calculate that at some point?
17%.
Well, that's the number I remember from past.
Yeah, I'll double check. It was about 17, but let me go back before I give you a true answer.
I think that would be just useful having that, since occasionally things come up about, what this town does for the county. I'd like to have an accurate number.
I'll get that figure and get that to you.
No rush. Okay, they were the only comments I had.
Thank you. Anything else from council? Thank you again for your thorough work and making it understandable. Even I always say this, but even a lawyer can understand your financial statements. So it's a pleasure working with you. Thanks for all your help.
Thank you.
All right, we'll move on to item 8B. I'm sorry, you have a comment, Heather?
Do we have to approve that?
Oh, yes, that's right. I'm sorry. So is there a motion to approve the audited financial statements?
So moved.
Second?
Do we need a roll call vote on this, or just an acclamation? All in favor?
Aye.
All opposed? All right, it's unanimous. Now moving on to item 8B, ordinance number 556, which is the property right element for comprehensive plan. This is our second reading. Mr. Town Attorney, do you want to?
Yes, sir. Thank you, Mr. Mayor. This is ordinance number 556, an ordinance of the Town Council of the Town of Indian River Shores, Florida, amending the comprehensive plan by adding a new property rights element, providing for applicability and severability, and providing for an effective date.
Thank you very much. This is the second reading. Are there any comments from council or questions that came up between first and second reading?
I raised a question with Mr. Sweeney yesterday because I believe that the property right element that's referred to in the ordinance is not a property right element that is established in Florida Statute 163, 3177. And we had a discussion about that, and I don't believe the statute contains an articulation of a right that all people have the right to participate in all land use plan processes. The statute identifies, I think, 4 or 5 specific elemental rights, and that is not one of them. So I defer to Mr. Sweeney on that.
All right, so it's a question for Mr. Sweeney. This, before I turn it over to you, Mr. Sweeney, this did pass approval from the division, so they approved the comments?
Yes, sir. And I'll have to also defer to our town clerk because I think she was the point of contact with the EO on the property right. It's my understanding that everything has come back, no comments, no objections, no problems from the state. The only one that I think we were still pending was DOT, and I think
We received that late last year.
late, yes. Yes, that was I want to confirm that. So we received nothing back negative or contrary from the state of Florida, which is good and exactly what we expected. As to this issue, as far as the ordinance, section 163.3177, which is the overarching comprehensive plan statute in Florida, the subsection of paren 6I2 in the statute, the Florida statute, is small and very limited in the sense that it says there are 4 subsections, and we've re-identified those in the language of the actual comp plan amendment, which is the Exhibit A as set out. And to Councilman Altieri's point, I believe that the reference in the 4th whereas clause, the right respects the rights of all people as a whereas clause. That again is a introductory clause and provides some of the groundwork. Arguably, it's something that somebody could point at some point in the future, but again, that specific term and again, I don't believe is included in the actual amendment, if I am correct, and I went back and checked all this again last night. So it is introductory, but it's not the actual language that would be in the comprehensive plan amendment, if that makes sense. I had to go back and double check that, Councilman Altieri. It is that term, as we spoke about on the phone, is broader than the language in 163-3177, which talks about the property owner. But again, I have to defer to council on the propriety of whether that should continue in the whereas clause or not.
Okay, so let me see if I can be of assistance here.
Yes, sir.
So the subject in question is really a statement of objectives and policies in the comprehensive plan. So to the extent that it would contravene any state statute or law, it would be considered ultra vires anyway. Is that correct?
I tend to agree, yes, sir.
Okay.
I mean, we're required to do this by state statute.
I think it's just a broader statement of rights. In the whereas provision, it's a broader statement of rights than is in the statute. And I believe this ordinance, right, I know that it's introductory, but the ordinance could be read in a way that would suggest a broader right of citizens of Indian River shores to participate in all land use planning processes. And I think that doesn't comport with the statute. We know what their rights are. They can come to this hearing and they can be heard, but they can't, not every citizen of Indian River County can participate in every land use process in Indian River shores, rather.
But they're public meetings. Is that what that language?
But they're not, they
Is that
can
the
come to a
language
public
in the
meeting,
intent?
but they're not identified as a participant. They're not an objector, they're not an intervener. They don't have the rights as an objector or an intervener.
Okay. Is participant defined in such a way in the statute, or?
No, sir. It's not. The section that's in the statute, here's the requirement. It says, in accordance with legislative intent, each local government shall include in its comprehensive plan a property rights element to ensure that private property rights are considered in local decision making. A local government may adopt its own property rights element or use the following statement of rights. And then there are 4 subsections which are identified in your packet at page 170 at the lower right. And as you see, you've got your 10.1 property rights, goals, objectives, and then it moves down into the goal, the objective, and then the policies of 10-1.1.1 through .4 are virtually identical to the state statute, which says the right of a property owner to physically possess, the right of a property owner to use, the right of a property owner to privacy, and the right of a property owner to dispose of. And then the final part of this section is the requirement that we have to adopt it. So again, the statute at the state level requires those 4 things or a variation thereof. We have virtually copied it. However, as to the introductory whereas clause, as you said, Mr. Mayor, these are public meetings. Any land planning meeting could be attended by any member of the public anywhere in Florida. As far as participation and evaluation of it, it's much like, it's a quasi-judicial proceeding, so it's much like a trial, so you'd have to give the appropriate weight and credibility to somebody speaking. And Councilman Altieri, we spoke about this. This is why we ask individuals when they come to the dais to identify their address. If somebody were to say they were from outside of the shores, outside of Indian River County, outside of Florida, quite frankly, that would, I assume, weigh into the credibility versus a next door neighbor or such.
Okay.
But the public process.
So we have 2 choices. We're at the second reading on this. It wasn't brought up on the first reading. In the grant context of what the comprehensive plan does and what this ordinance does to adopt the comprehensive plan amendment, I'm comfortable moving forward with the second reading and approving the second reading. The alternative would be to redo this all over again, go back and wordsmith, some language that, quite frankly, I don't think is all that germane to what we do when this comes before us. If anybody from Indian River County came in and wanted to weigh in on to the extent we would have any grand land development issues or easements and mineral rights, somebody wants to drill for oil, we would of course be bound to let them speak.
Yes, sir.
So as long as it's not participant with a capital P, and we have the right to interpret it as I believe we do, as participant with a lowercase p, with all due respect, I don't see the importance to derail this and then go on to a new ordinance and go through the process again. So that's my opinion. Is there any other discussion from council on this? Any, Councilman Altieri, do you?
My only concern is that this is an ordinance. This isn't just preliminary language, this is an ordinance. And the ordinance, I think, speaks to a right, and it speaks to a right in a very, very broad way. And I think it speaks to a right that's not there. There's a legal distinction between a participant and somebody who comes to a meeting and only has the right to comment. There's a difference between someone who comes to this chamber and says, I want my 3 minutes. That's different from being an objector or an intervener in a planning process.
Okay. All right, thanks. I think the point is clear that you're making. I'll ask for either a motion to table this or a motion to approve the ordinance, and then we'll see if we get a second.
Motion to approve the ordinance. Second.
All in favor?
Aye.
Mr.
No,
Mayor.
roll call.
Roll call vote, excuse me. All right. We will do a roll call on this since it is an ordinance. So there's a motion and a second on the table to approve the second reading.
Mayor Foley,
Aye.
Vice Mayor Carroll,
Aye.
Councilmember Altieri,
Aye.
Councilmember Atwater,
Aye.
Councilmember Smith.
Aye.
That being said, thank you for bringing this to our attention. It's, it's always, this is law day, it seems like. We had a discussion on the pending legislation and then a spirited discussion of this. But thank you for bringing that to our attention. I do think, though, Mr. Sweeney, we should bear this in mind if we should have occasion in the future, which again, I'm not sure is how remote or not remote it is, that, we take a fairly firm position on what participant means and, that we stick with our own interpretation of it. And I know under Florida law, this council has broad discretion to interpret its own ordinances so long as it doesn't contravene a clearly articulated statutory policy.
Absolutely. Yes, sir.
All right, thank you. Let's move on to item 8C, ordinance number 557, cemetery rate changes, and that's the second reading.
Yes, Mr. Mayor, if I may. Ordinance number 557, an ordinance relating to Johns Island Cemetery, clarifying various provisions of Chapter 93 of the Code of Ordinances of the Town of Indian River Shores relating to restrictions on sale of cemetery lots, providing for applicability and inclusion, providing for severability, and providing for an effective date.
All right, are there any comments or discussion between the first and second reading?
I have one question. On page 172 in the background material, it says ordinance requires the owner of the certificate to be a resident property owner within the town. How does that come into play when somebody passes away? And if its certificate's owned by, say, a child or something like that? That confused me.
They've always allowed the certificate to pass on to the heirs
Okay.
of the owner, but to purchase, you have to be a resident at the time of purchase.
Okay, but it could be transferred to somebody outside the town. Okay, that was my only question. I was just trying to figure out that conundrum.
All right, thank you, good question. The most important part of this is that I don't have to sign the certificates anymore, right? So I think that's the main thing. Is there any other
You're
discussion?
going to get a cut in your pay.
That's right, they're gonna have my pay. Any other discussion on this? If there is no further.
Just a point of order.
Yes.
I am on the waiting list, I think. So I have a personal financial interest in this vote. So technically I have a conflict of interest. I can extinguish that conflict of interest by saying that I'm inclined to vote in favor of it, even though it's against my financial interest to vote in favor of it, or I can recuse myself.
I think in this case, it would be most appropriate to recuse yourself now that you've publicly stated you are in line for this and a potential change to this could be a pecuniary benefit to you. To vote in favor of it.
Then I'm the same as Jim.
Okay? Well, So both of you in disclosing that would be required to fill out the appropriate disclosure form that the clerk has subsequent to this meeting. And as a result of that, we still have 3, I assume, council members that can vote in sustained form on this.
Yes, we don't plan to die, so.
Good. Excellent.
All right, with the 2 recusals noted, is there a motion to approve the ordinance?
So moved. Second?
All right, we'll have a roll call vote.
Mayor Foley,
Aye?
Vice Mayor Carroll,
Aye.
Councilmember Altieri,
Abstain?
Councilmember Atwater,
Aye.
Councilmember Smith.
Abstain.
Let the record show it passes 3 with 2 abstentions.
Right, just, Pete, we're getting into a lot of legal stuff today, but
Yes, sir.
the abstentions should be noted as recusals, not abstentions, because there's no abstention permitted in Florida.
That is correct. Thank you.
All right,
Yeah.
so,
Thank you.
all right, so Madam Clerk, let the record reflect the abstentions were recusals.
Thank you.
All right, so item 8E, ordinance number 559, tree protection officer. This is the first reading of the tree protection officer.
Mr. Mayor, we have ordinance 558, I believe.
I'm
sir.
sorry.
Yes, sir.
Floodplain.
Yes, sir. Yes,
Sorry,
sir.
my computer jumped.
No problem.
Ordinance number 558. Is there?
If I may read, sir.
Yes, please.
Ordinance number 558, an ordinance by the town of Indian River Shores, Florida, to amend the Land Development Code, Title 16, Chapter 165, Floodplain Management and Damage Prevention, as stated in Ordinance 548, to amend the Code of Ordinances, Chapter 150, Building Regulations, adopting technical amendments to the Florida Building Code as stated in Ordinance 548, providing for applicability and inclusion, providing for severability, and providing for an effective date. Thank you.
All right, is there any discussion? This is a first reading on the ordinance, so if there are any substantive discussions on ordinance number 558 as proposed, let's begin, starting
I think I asked this before, just.
Councilmember Smith.
If we approve this, then it will help people's insurance rates. I think I asked that and I was told no.
So,
That,
yes.
that's what I'm concerned about.
And this is, I'll mention this very briefly because I'll also follow up, but this is just one piece of our move towards CRS Class 5, which will be a benefit to the insurance rates overall once we go from 6 to 5, and this is a large point piece of that. And I would just refer everyone to we've had the presentation that we had on, and then I think we'll move back in September, October overall. But it will eventually be a benefit both in resiliency and economics.
Okay, so as soon as we get the rating changed, it'll benefit everybody.
Well, it doesn't benefit individual applicants for insurance coverage because you have to meet the individual underwriting requirements of the individual insurers, many of which require you to be 2 feet above BFE. So unless you are at that, the fact that we're changing this institutionally is not going to affect individual applicants for policies to get a benefit.
So if their house
And in
is.
fact,
I disagree with that. On federal flood insurance, it's based on the CRS rating. If you're outside of zone X, like AE, I think, which in those zones, which cover a lot of Johns Island. So for the federal flood insurance.
No, I agree with that.
Okay.
I do agree with that, but for individual first-party property insurance, it will not assist individual applicants for policy.
Yeah, I see that as a different issue. We talked at previous meetings about things we can do to raise our community standards, and we're going to have a presentation from Mr. Harpering. He was tasked with doing that. I think we gave you till May to do that, is that right?
Yes, I accepted today to do it.
Okay, excellent, wonderful. So, all good points, but I think the individual insurance rating and relief from that is related to this, but it's not really what drives the approval of this ordinance. So, all good points, though. Are there any other comments on this? If there are no other comments, may I have a motion to approve?
So moved.
Is there a second?
Second.
We'll do a roll call vote.
Mayor Foley,
Aye.
Vice Mayor Carroll,
Aye.
Councilmember Altieri,
Aye.
Councilmember Atwater,
Aye.
Councilmember Smith.
Aye.
The resolution passes unanimously.
Thank you. All right, now we move on to ordinance number 559, which is the Tree Protection Officer, and this is the first reading of that ordinance. Mr. Town Attorney?
Yes, sir. Thank you, Mr. Mayor. Ordinance number 559, an ordinance amending chapter 167.02, tree protection, B, definitions of the Code of Ordinances of the Town of Indian River Shores, and providing for an effective date.
All right, this is a first reading, so let's have some discussion on this item if there is any. Start with Councilmember Smith, move from right to left.
I had called Jim and we had spoke briefly about the position, and I understand that this is a private contractor, and this simply says that we have upped his qualifications in order to fill this need if we need it. Right now, it's not that way. Is that correct?
That's correct. It's fairly narrow right now,
Right.
and by expanding it with language that's consistent with some statutory provisions, it will just simply help the town administratively and in terms of continuity operations.
Okay.
Any comments from Mr. Altieri?
I had comments just about the language of the definitional provision. I raised those comments with Mr. Sweeney yesterday. They were basically, some of them were stylistic, frankly, but others just had a concern about the credentials of the person who would be the candidate for this job. And the current articulation of this says the person should be a licensed landscape architect or have undertaken an advanced course of study at an accredited university in either landscape architecture, horticulture, botany, and I don't think horticulture applies. It has to do with plants. Botany shouldn't apply. That also has to do with plants, not trees. It really should be somebody, I think, in dendrology, which is the study of trees. So some of these things were stylistic, some of them were a little bit more substantive, and I've shared my thoughts with Mr. Sweeney and suggested maybe a revision of the language just to tighten it.
Mr. Mayor, if I may just address that briefly?
Sure.
So that particular language is language that I determined to keep in there because that language fits the actual qualifications of the person that we have doing the job now. If we're to delete, modify, amend, then that would be a concern, which would counter the whole purpose of the change in the ordinances, which is to give us an opportunity for broader coverage, because right now we only have a single person that is available to do this work for us. And if he twists his knee or hits the lottery, right now finding someone either with the current qualifications that are listed or with the enhanced ones for this type of work will be, I think fairly prohibitive to find an individual. So what I did was essentially leave the majority of the language the same that would allow our contractor to continue working for us, but then add the language in state statute related to the certified arborist or Florida licensed landscape architect, because those specific qualifications in statute allow a homeowner to have that person designate that their tree is a hazard, can't be mitigated, and can be pulled out without ever coming to the building department. So the state statute allows someone to make that determination, and I wanted to be able to retain someone for the town with those same level of qualifications. And we, of course, will be putting out, and I'll mention this briefly now, but elaborate in a moment, we will be putting out requests to the community through, requests for proposals to help us cover these things, and that's why we wanted to expand it this way. But had I added or deleted those other items that you referenced, we would have immediately excluded the individual that is qualified under our current definition that we have now.
Because he or she is a horticulturist or a botanist?
Because, yes, Mr. Doyle has those particular qualifications, and we have all those on record, and they fit within the definition as it exists. My whole goal is to give us a little broader range of people to come in and do this work, if needed, with the qualifications that match state statute.
All right, thank you. I just have one question. My recollection was maybe 3 sessions ago, legislature passed a statute that greatly reduced the qualifications for somebody to remove a tree, for example, and this is how this arises in our context mostly. Is this consistent with that statute, or do we have greater protections?
Yes, our overall tree protection ordinance is much greater than what the state statute allows, but in this particular area, the preemption allows for those particular qualified individuals to basically make that call without ever contacting the town.
Okay, all right. So, true, unrelated, as they used to say in some exams that we took, right? So, all right. Vice Mayor Carroll, do you have any comments?
I have a question about authority. I recall vividly about a year ago, a situation at Johns Island where there was a plan put forward to remove trees in order to enhance the growth of certain areas of grass in certain areas of the golf course. And it turned out to be, from my standpoint at least, very controversial. Permission was given, permission was taken back, and the process did not flow from my recollection as smoothly as it should have, because no one really knew who had the authority to make the decision. So my question is, what is the authority granted to the tree protection officer?
In any context in that regard, it would be the tree protection officer has to make, doesn't have unilateral, conclusive decision-making powers. Makes recommendations, those have to come before planning and zoning, and then eventually to the council here on any of those narrow scope of decisions where, let's say, you couldn't get a certified arborist or you couldn't get a Florida licensed landscape architect to make that determination, but somebody still wanted to remove the tree. Our tree protection officer would go out and review it and make a determination unilaterally on his own as far as the ordinance, but their check and balance still occur. That would not be the final determination. It would have to come through planning and zoning, building department, myself, and eventually the council to determine whether or not that call, so to speak, is appropriate or correct.
Okay, got it. Thank you.
Councilman Elwater? No. All right. So I appreciate Councilman Altieri's comments, but I note that the language raised about horticulture, that's already in our existing ordinance.
Yes.
And so we would not be making a change to it. I agree with this point. In a larger municipality where things would fall through the cracks, I would be a little concerned about somebody having a horticultural degree and start making decisions about trees of special concern. But
That was the point.
But with the layers of fail-safe that we have and knowing practically how things work, nobody's going to be denying or taking down trees in any of the communities here of any special concern without it passing by your desk. So with that being said, I'm comfortable with the ordinance passing first reading here. So with that, I'll entertain a motion either to table the ordinance or to approve the ordinance.
Motion to approve. Second.
All right, roll call vote.
Mayor Foley?
Aye.
Vice Mayor Carroll?
Aye.
Councilmember Altieri?
Aye.
Councilmember Atwater?
Aye.
Councilmember Smith?
Aye.
Let the record show that motion passes unanimously.
All right, another good discussion. Qualifying dates, ordinance number 560. This is a first reading. Mr. Town Attorney, my understanding is this is to expand and change the dates for qualifying for council elections to make it a little bit easier for residents to put in the paperwork.
Mr. Mayor, and in conjunction with our town manager, yes, that's an accurate explanation. It's creating a defined window that will now be codified in the ordinance. And it will be essentially, as you can see there, let me read it in a minute, but as you can see from the language in section 1C, it would add the time frame from the meeting immediately after the April to the May meeting. So if I may, Mr. Mayor, I got ahead of myself, I should read the ordinance title.
Please do.
Yes, sir. Ordinance number 560, an ordinance of the Town of Indian River Shores, Florida, amending Article 1, Section 32.02 of the Code of Ordinances by providing for specific qualifying dates for candidates, providing for severability, providing for conflict, and providing for an effective date. Thank you.
Terrific. Is there any discussion on this from members of council?
Yes.
Please, Councilman Elwater.
Pass that one, please.
Thank you.
This past Monday, part of my discussion at the supervisor's election with Leslie Swan was to ascertain what was the last date that she needed to get our slate of candidates in order to have enough time to get out ballots to foreign voters, primarily those in the military. She told me 81 days. I said, "Are you sure that gives you enough time?" She said, "Yes." So what the sheet you have in front of you is I know we don't have an election this year, but if we did, it was the first Tuesday in November, it would be November 7th. And I worked back on the calendar, 81 days is August 18th, 2023. So that would be the minimum that she would need. I have an issue with moving this proposal, moving it back all the way to essentially 6 months, and or 5 months. I think asking those who might be on council if they want to run for re-election, or those who may wish to run that far in advance, I think is unnecessary. I understand about the qualifying period and so forth, and people being around. What I would suggest would be the following. I use this example here. If you look down this page here, Thursday, June 29th, which would be our town council meeting in June, to November 7th, just as an example, is 131 days. The next council meeting was Thursday, July 27th, and if it was the election this year, to November 7th, be 103 days. What I suggest would be that we would expand the period out. There's no reason why it has to be a week's time. I think that's just an artificial artifice that our previous town clerk put in for her convenience. It's not like we're asking the town clerk to be hanging out here just to take the qualifying documents. She's here doing many other things. That we move the qualifying period closer to the election date and make it wider, so that if there's some objection about people being around or not being around, if they can't make it during this time period, frankly, I have to ask myself, well, you know, being on council does require you to be in the town a fair amount to observe what's going on. We're giving them roughly a 30-day period, but it still gives enough time for somebody to think about if they want to run, that it's not so far in advance. So I haven't worked up the language of what that would be. So I would suggest if other people agree with my idea, that we table this ordinance and rewrite it so it matches up, tracking Thursday to Thursday in terms of council dates and so forth.
Before I ask the other council for comments, is there any restriction on how long the qualifying period can be?
Not that I'm aware of.
Okay. So my concern is that there are some eminently qualified people who volunteer but have lives outside of the town of Indian River Shores, and I would like to encourage them to think about it before they go for the season. So I like the May date, but I'm persuaded by Councilman Elwater that people sometimes don't focus on things until there's a deadline. So it seems to me as if there's really no downside to expanding the qualifying dates, why not hold it open for a little bit longer? That's my general thought. The exact dates, I'm open to discussion on council. So with that, Vice Mayor Carroll, by the way, I'm term limited, so this no longer affects me. I don't think it affects you either, but I remember when I first ran, trying to figure out, my gosh, I've got like 3-4 days here before I have to put all my paperwork. What happens if I don't get it right and, I don't execute the oath of office? So I think personally for our successors and to encourage people to think about it more than just for a couple of days or weeks, that it would be better to have an expanded time. But
Do they have to be physically present to put in their qualified documents? Can it be done, via Zoom and electronically, with, PDFs and scans and so forth?
That I'm aware of at this point, everything has to be physical documentation. I'm not aware of any electronic submission or Zoom.
Not to interject, some clerks actually require you to go and sign the oath in front of that clerk, the current clerk. So, that was one of my mistakes. I had it notarized, and I was told by our then town clerk, well, you have to redo this, and fortunately, I had an extra day. So anyway, enough from me. Vice Mayor?
Well, speaking from experience, with the August date, I forget the exact date now in August, but whenever it is. For me, it was a vexing period because I wasn't going to be here. And I assumed that the way my situation was handled, the town clerk was handled appropriately, which is to say that I filled out the documents before I left, had them signed, and did all the things I needed to do, and left them here. And the former town clerk accepted that as my MO for qualifying. I think, from a personal standpoint, that it would be better to expand the period and to have the period be further out, if only for the purpose of it being more convenient for someone like me who may not be here in August but is here in late May. So I'm all for expanding the period, and the period that is in the current ordinance suits me just fine. And I do think that it's important to have deadlines. I do think that it's important for those who are interested in running, think clearly about it, think hard about it, and knowing that there's a deadline in whatever the exact period here is, in May or April. I think that's fine. So I'm all for the ordinance as written, and that's how I would vote if it comes to a vote today.
Councilman Altieri, it's more likely to affect you than anybody else.
Yeah, so I don't have strong feelings about that issue, but I have a separate issue, which I brought to Mr. Sweeney's attention yesterday, that I think technically we should be amending 32.02A as opposed to adding a separate provision, 32.02C, because 32.02A essentially incorporates Chapter 99061, which is the statutory provision which sets up the qualifying period. So rather than have two provisions in one ordinance that deal with timing, we should simply amend 32.02A to incorporate the provisions that are in the proposed ordinance. Otherwise, we are going to have an ordinance that says, notwithstanding the provisions of 32.02A, we're making a different rule. Statutorily, I think it's cleaner to do it the other way.
Okay, let's stick to the first issue first. How about the time period expanding? I'm trying to get a consensus from council. Do we want to keep it the way it is? Do we want to expand the time frame so that you can go from May up to August to do it? What's your preference for that?
I have no opposition to expanding it in accordance with what.
All right, thank you.
Councilman
Yeah, I have no opposition to expanding it.
All right.
Because we can do it whenever we want.
Mr. Mayor, if I
Yes.
can just elucidate on that very quickly. Yes, there is no requirement or threshold that it be a certain amount, because as you may already be aware, there are people that have already filed for constitutional office, such as the sheriff for Ingham County. There's already 2 candidates, and we're well in excess of a year of that. So we could have it be as long as we want, 10 to 110 days or longer. The other part, in conjunction with your meeting with the supervisor and my conversations with Ms. Swan, is that the 81 days is her internal debt. That is not a deadline other than that's for her to be able to get those ballots to overseas members, which is the main reason why. But other than that parameter, you may do whatever you want.
All right, understood. So I'm going to have a suggestion here, which is, I'm going to suggest that a motion be made to table this ordinance to clean up the scrivener's concerns that Councilmember Altieri has. You and the town attorney can get together on that and make sure you're connected, because quite frankly, without having the statute book in front of me, it's hard for me to do it. But I tend to defer to the town attorney on matters legal. I view my function as, policy related. But by all means, satisfy yourself that, that it's consistent, and then propose, what I'm hearing from council is an expansion of the qualifying dates from May to August. I think the longer the period, the better.
What I would suggest is maybe May through the end of July. That gives our town clerk plenty of time to hit that 81-day requirement.
That's
So
a
maybe, it could be
it's a fair
May,
point.
June, July, 3 months.
It's a fair point. The clerk is involved in this. What say you on this?
The ordinance was proposed only because of what we had found in the past, the difficulty for the time frame that the prior deadlines were. I have no objection, and the manager and I did speak yesterday to putting it for last Thursday in May through the last Thursday in April. I have no objection to any. I can't imagine. The timeframes have been pretty much limited because of the paperwork involved. Should you have 10 candidates? Should you have many candidates running? But because I don't anticipate that to be a problem, I don't care how long the timeframe is.
Okay. So, as it was once said, it's not that you're apathetic, you don't really care.
I just want to make it convenient for candidates to be able to run.
I appreciate that, and that's my concern too. I think we should make it as easy as possible for people who are interested in getting these high-paying jobs up here to do it. So there was a comment, I think, from...
Mr. Mayor, in my discussions with our town clerk and town attorney and others, we were trying to tie this to council meeting days, so if we wanted to expand it, we had discussed the first day after the meeting in April through the, like noon on the first day after the meeting in July. That would give us plenty of time. That covers 3 council meeting dates.
Terrific. So why don't we, I think we're in consensus. Why don't we entertain a motion to table it? We'll have an ordinance come back at the April meeting that conforms with the discussion up here to be presented before council.
Motion to table.
Second.
Do we need a roll call vote on the motion to table? I don't think so, right? All in favor?
Aye.
Any opposed? Okay. Let's move on to item 8G, which is resolution number 23-02, the budget amendment. Are there any comments, or is there any discussion on the budget amendment? If there is none, I would entertain a motion to approve.
So moved.
Second.
Roll call vote?
Mayor Foley?
Aye.
Vice Mayor Carroll?
Aye.
Councilmember Altieri?
Aye.
Councilmember Atwater?
Aye.
Councilmember Smith?
Aye.
The record show it passed unanimously.
Terrific. All right, we're going to move along to item 8H, which is resolution 23-03, cemetery fees. And before we do this, I just have a question for our town attorney. Going back to the recusal of the two council members because of their interest in cemetery plots, my understanding is that if the council members are just members of a class, generally that would benefit as opposed to individually, they don't need to recuse themselves. So I agree on the last one, it was out of an abundance of caution, but do you have an opinion for us as to whether or not they can vote on this resolution? I'm not worried about today, we have a quorum, everybody's here, but in the future, if we're down a man or a woman, we may not have a quorum to proceed on these unless we have some clear guidance on recusal.
Yes, sir. Thank you, Mr. Mayor. Council, I agree that there's a very clear delineation between the ordinance that was just passed versus the resolution setting the fees, and your assessment that as a class grows, it's basically a benefit analysis to the person. If you were to vote on something that would benefit clearly you directly, that's one thing, but if you were talking about maybe a municipal services benefit unit or taxing unit that had 5 members and you were one of them, that would be a very low threshold and probably would be viewed as benefiting you. If on the other hand, such as setting the millage rate for the town, which affects every single person, or something of that nature, that is not a recusal basis. In this case, I believe the ordinance changed the dynamic of how they can be transferred, so there would be a pecuniary benefit potentially or not. In this case, we're simply talking about a universal rate that would apply regardless of if it was a council member or other certificate holder. So I do not believe recusal is necessary for this resolution.
All right, thank you.
Yes,
Thank you
sir.
with that clarification. With
Yes, sir.
that, are there any comments or is there any discussion on cemetery fees? Is there a motion to approve the resolution? Is there a second?
Second?
We'll have a roll call vote.
Mayor Foley?
Aye.
Vice Mayor Carroll?
Aye.
Councilmember Altieri?
Aye.
Councilmember Atwater?
Aye.
Councilmember Smith?
Aye.
Record show it passes unanimously.
And I would note you raised to increase your own fee someday, so.
I don't want to use it.
Well, that's true too,
Yeah.
All right, item 8I, resolution 23-04, building permit fee change. Mr. Town Attorney or?
Mr. Mayor, because this is a resolution and not an ordinance, it's not required to be read in title. However, I would defer to our town finance and as deputy manager on the basis for this based on the state statute.
As I told you when we did the budget back over 6 months ago, I was going to be monitoring the fees for the building department, and because I was doing an estimate trying to figure out how much we needed to raise them. I just did the 5-month analysis, and we do need to raise the fees for the building department, so we are not pulling from the reserve, which is actually has met state statute now.
All right, and for the benefit of me to remind me and for others to remind them that may have forgotten too, this is a fund where revenues are restricted in terms of what we can spend them on, so you
That is
carefully
correct.
monitor intake versus outtake because we can't transfer excess to the general fund, is that correct?
That is correct. This needs to be used for building department purposes only. It's not for planning, it's not for zoning, it's for building department purposes only. We do have a little overhead that we do based on time, but it's not much. We can only maintain a average 1-year balance based off the expenditures from the previous 4 years. So it's 1-year balance, so.
Thank you very much. Any questions? Is there a motion to approve?
So moved.
Second.
Roll call vote.
Mayor Foley?
Aye.
Vice Mayor Carroll?
Aye.
Councilmember Altieri?
Aye.
Councilmember Atwater?
Aye.
Councilmember Smith?
Aye.
Let the record show it passes unanimously.
Thank you. Item 9A, we're going to do staff updates. 9A is the building official report and statistics. Mr. Martinez.
Good morning, Council. The building numbers speak for themselves. You've all had a chance to look at them. If you have any questions specifically, I'd love to answer them for you.
Any questions for our building official? Just one.
Yes, sir.
You know, before you see the wave, there's always a change in the current, right? So what are you sensing in the office? Is there an uptick in activity, about the same, or a downtick?
It went down, it's starting to come up a little bit, I see it. Waiting for the summer months. We've taken a lot of permits for demolitions of single-family homes, so I assume their building permits coming up behind them.
Okay, yeah, so let me, inartfully ask the question. Not simply the applications for permits, the permanent ones, but people come in, pre-planning and stuff like that. What's your sense in years past? Is it about the same level of activity, a little less?
I would say about the same.
Okay.
Yeah.
All right, terrific. Thank you. Anything else for Mr. Martinez? All right. Item 9B, the town treasurer report.
You've received my monthly report. I really don't have anything else to report. You've already done the audit and everything else, unless you have any questions for me.
Anything for Heather?
Thank you.
All right, thank you. Item 9C, Chief Rozelle, Public Safety Department report.
Good morning.
Good morning.
Does anybody have any questions before I start? Okay, the mayor had mentioned earlier about the construction and the traffic delays and going on A1A. There's also been an increase in aggressive driving, and I think some of you may have noticed it or maybe got complaints. We're getting complaints like we've never had before. So we've put extra patrols out there to make certain that we're keeping the speed down. I think a lot of it has to do with the fact that it was 50 miles an hour in the north part of town, and they lowered it to 45. But we're out there. The intent is not to pile citations on people. We're going to give them warnings for a couple of weeks, and then hopefully the message will get put across. And if we have to do it for another couple of weeks after that, we will. We're even getting complaints of speeding on Jungle Trail, mostly from the garbage trucks, not Republic. Just so you know. We have a new device that we purchased. Thank you to you. It's a handheld sonogram. It's about that big. And it's a revolutionary device. Nobody in the county has it. Nobody yet is using it on an ambulance. What that means to your constituency is if we get a call, let's just say somebody has an aortic aneurysm or some type of low blood pressure or event where we suspect there might be a bleed, an abdominal bleed, or even something simple like we can't find a vein. This sonogram will enable us to diagnose those things immediately rather than wait to get them to the hospital. Now, you're always in good shape when you get in the ambulance in this town anyway, but this enhances our ability to keep you alive, to get you to where you need to be, and it'll even make it easier for us to make the determination quicker as to whether to medevac somebody out rather than take them to Cleveland Clinic. And it's all because you allowed us to buy it. Mark Shaw has been researching this for a couple of years, but the technology finally caught up to where the portability of it is reasonable, and that's why we're doing it.
Perfect. Thank you. Anything for the chief?
Just one quick question.
Yes, sir.
I've had a number of complaints from people on A1A that complain about certain of the traffic control signals. They're the ones that blink amber, so they don't go from red to green. There's one by Carlton, and I think there's one south of us maybe. And the complaint is that since they're blinking a cautionary color, the pedestrians on the blinking of that light, pedestrians then feel free to cross A1A, whereas drivers don't take that as a stop sign, the blinking of the amber lights. And I've had people saying that they've approached the crosswalk, pedestrians in the crosswalk, and then they've had to move out to the right because people are barreling down behind them, not seeing a red light. And I wouldn't raise this, but I've heard it like 5 or 6 times from people about, it's particularly the one that's been brought to my attention is the one that's just by the Carlton.
I'm in agreement with you, but I don't believe we have any play in that. The town manager can correct me if I'm wrong. That's DOT's. I think that's their policy. That's their procedure to put a yellow blinking light rather than a red one. I don't know that I've ever even seen a red blinking light. It does make sense. You're supposed to stop when somebody's in that crosswalk. But I don't know of any places, even the one down in by the park in Vero Beach is yellow blinking.
I just
We
think
could,
it
we could
sends-
research it.
It sends an
For sure.
ambiguous signal to two different
Yeah, I agree.
constituents.
No, I completely agree.
The walkers and the drivers.
I couldn't agree more. I think it's worse.
In fact, some
If there are no
drivers,
lights.
some drivers think an amber light at a regular traffic light means speed up so you can get
Correct.
through it.
That's
So,
exactly-
no, we're in agreement. We could research it and see if DOT would be amenable to changing it to red. I agree.
I know we don't have control, but maybe we can raise our hand.
Right.
Great, thank you.
With regard to the speed limit dropping from 50 to 45, what I noticed on my car, it has a heads-up display. And as part of it, it puts the posted speed limit up there. It still shows 50 miles an hour. I don't know who we can
It does.
contact to change that, but every time I look at that, I'm saying, I know this is 45, but it pops right up in there.
It's funny.
I imagine this
You're
is
100%
happening other
right.
places.
It does. You're not the first person to tell us that. In fact, when we pull somebody over in that, it's often that somebody says, it said in my GPS that it was 50 miles an hour. DOT changed that without telling, well, they told us at the last minute, without any input from us at all.
Well, they had to change it, I'm the one responsible for that, because they
Oh,
wouldn't
thanks.
put in the 7-foot bike lanes if we didn't lower the speed limit
Yeah.
through. But is there someone that we can contact to try to get this changed in the database? Do you have any idea?
The GPS, whoever GPS it is to use, those companies, they update, every
They're all
year,
different,
6 months.
Waze, Google,
Yeah.
Land Rover. So my Land Rover has gotten the memo, but, my
Okay.
other car hasn't.
Yeah.
So it's bizarre.
All right.
But I think Councilman Altieri's point, if we can, I think we'll put all the weight of council behind kind of clearing it up, because even outside of our jurisdiction down by the church, it's not even ambiguity. It's a false alarm to both parties. And, there are near misses that are happening. Personally, I think having the blinking lights is worse than having nothing at all. Because if you see a crosswalk and a concrete stanchion, you're gonna proceed more cautiously. So,
And I think it's written in the law that you're in a crosswalk, you're supposed to stop for the pedestrian.
right.
You're not supposed to yield, which is what yellow implies.
yep. So, Councilmember Smith, you had,
I was just going to ask about the training on the new piece that you just got. Was there a lot of training for that?
Yes, Dr. Ford, our medical director, spent the last 3 days training. I believe we have almost everybody. I think there's 1 or 2 people that were on vacation that he's going to come back and do, but the training occurred this week. Everybody is proficient enough to use it, but you get better at it when you start using it. So anytime somebody gets in the ambulance, they're going to mess around with it. Start by looking for a vein, using that to look for a vein. So it's pretty cool. If you ever want a demonstration of it, man, you know where to find us.
Thank you.
And thanks for going to that event yesterday at the Meals on Wheels. I heard that you were.
Oh, it was amazing.
Isn't it? Yeah.
I can talk about it now, just or wait till I...
no, that's fine, go ahead.
Yeah, no, I had gone over and they had a little presentation first, and then there were quite a few people there. There was a lot of people from the city, the commissioners and different representatives. And then we went out and delivered the meals. I mean, they do an unbelievable amount of work for an unbelievable amount of people, so it's a good organization to support. And actually going out with a volunteer to some of the homes, very enlightening.
It is. Yeah, we send a couple of guys out there every year to
Yeah,
help
it's
them
good to
out.
see them there. Okay, yeah, thank you.
Terrific. Anything else for the chief?
Yes,
Councilman
sir.
Elmore?
It might have been 2 or 3 meetings back, my recollection, I think, but you were talking about there was an issue with burglaries at the north end of Vero Beach, abutting our town, and you guys are keeping an eye on that. Is there any update on that?
There's no update on that other than they have slowed down. They did not impact the town.
Okay.
We're tracking some burglaries that have occurred down in the moorings, and they're all car burglaries. So we're not overly concerned about that now, but we did put some extra patrols in the area in the southern part of our town. It's not time to panic just yet, but we are tracking them through the county.
Great, thanks for everything
Yes, sir.
you and your guys do.
Well, thank you, sir.
As usual.
Thank you.
Item 8C, Public Safety, 8D, Public Works Department.
Just a real quick update. Lewisburger is no longer maintaining our A1A district for vegetation and sidewalk. It's back with FDOT in-house. I do have a direct contact with them now to where we can, if something comes up or arises, we can have it looked after immediately. Other than that, the beach project's just about sealed up, and I don't have anything else for you.
Any questions?
Nope.
Councilman Atwater?
I don't know if this is appropriate to ask you or ask the town manager, but in riding my bike yesterday, the path along A1A, there were at least 7, maybe 8 sections which were torn up, I presume by Florida City Gas. Do you guys have any information on when that is going to be fixed? I mean, it requires, if you're riding your bike down that path, to dismount.
So I have been in direct contact with the contractor on that, and they are working diligently to proceed forward on fixing everything. They've got one section here that we've had that was in major concern because they completely tore the concrete completely out. They actually came back in and put a temporary patch in. They have to cut several lifts from where the concrete's been broken. So I've done a survey completely, and I've also addressed it with FDOT at the same time to make sure that they are aware of the situation too. So,
okay, but do you have any time?
I don't have exact time
Okay,
frame,
all right,
but yeah, they're getting.
All right,
they're
well, it sounds like you're on top.
If you see a white truck that says White City Land Clearing on it, they're the contractor that's completely filling in those gaps. All right?
Thank you.
Thanks, Larry.
Code enforcement.
I have Sergeant Mike Grants out on a task that came up this morning. You've received the report. I will just note that the code enforcement arm of the town continues to work smoothly and better under the current structure that we have it in. And I will note that I haven't really seen a decrease in information that we get based on the statutory requirement for people to identify themselves. But we're out there, and I thank the chief and Larry and all of their personnel, because we've tried to just change the paradigm in terms of visibility and awareness. And as always, if there's any issues or problems, please get with them directly. We'll take care of them.
Thanks. No, and I appreciate Officer Mike Grant's comprehensive reports. They're very helpful, and it's in my view, it's an important function, acting as a mediator between neighbors who may otherwise escalate a dispute because they don't like what kind of vehicle is being parked in someone's driveway or what the contractor's doing with the dumpster and the garbage. So tell them to keep up the good work. Anything else on code enforcement? Let's move to the town attorney report. You've had a busy day. Do you have anything else left to say?
Barely, Mr. Mayor, and I promise. Thank you, Council. Just two brief things to update the Council on. First would be just overall session. As I mentioned before, the session is about halfway done. It started on March 7th. This is the Florida legislative session, and will adjourn on May 5th. Two bills that had garnered some attention relating to municipal oversight of municipal utilities, including water. Those bills, including House Bill 1331 and Senate Bill 1712, both have moved through and continue to move through the process. As this council is aware, there's multiple steps, multiple different committees that have to receive it before it goes to the final floor for a vote. None of these have made it to the final floor for a vote yet, and I certainly don't want to be premature on it yet because some versions of them have died, become amalgamated. I know, Mayor, you've been intimately aware of it, but again, they are moving forward to some degree, being modified, being amended. If they have any specific questions about the implications of what they may be in final form, please reach out to me directly. So, like I said, if you have a holistic question, I'm happy to answer it, but if you have specifics, please reach out to me. And again, I don't want to be presumptuous because we still have roughly 40 days left, or thereabouts, 35, and who knows what happens until I have to those days. The only other additional item of note to bring to the council's attention is we will be attending oral argument in the appeal of the state reuse water case, town of Indian River Shores with the city of Vero Beach. That is next week. I know the mayor will be in attendance, as well as myself and Mr. Harpering. Our outside counsel is imminently prepared, and we're looking forward to it. I don't expect that we would receive something, as the mayor said, from the bench. In fact, I've never heard of that happening at an oral argument, but we should get maybe some flavor depending on the questions.
Is it Tuesday?
Yes, sir. Yes, sir. And that'll be live and in person at the 4th District Court of Appeals. It's also available to watch online.
We have a rough time.
I believe we're 10?
10 a.m.
I'm sorry, yes, 10. Yeah. I will forward the notice, yes, sir, to all council.
They stay pretty tight in terms of the time allocated for argument in the fourth. So
Very tight.
Yeah.
I mean, we will be presenting from a dais, it will have a green, yellow, red light, and my experience in arguing there is, at a red light, your tongue better be tied.
So it's scheduled for 10 o'clock?
I will confirm that before we adjourn, yes, sir.
Okay, I'm gonna be down there, so I'm gonna
Yes,
hop
sir.
in. Is there anything I need to know? Just go to the courthouse and just show up?
The 4th District Court of Appeals is a very small courthouse.
The address?
I will provide it in just a second, yes, sir. But you just go through the metal detector and you'll be able to see.
Maybe just send a note.
Yes.
All the details, address, and we'll figure out how to get there.
That'll come out to all of council by today.
Thank you.
Yes, ma'am.
Terrific. I just have one, in light of, just occurred to me as we were going through the ordinances that if we could have a soft procedure so that I know we all get the proposed ordinances for first reading and resolutions for first reading. Forget the resolutions, those are easy, but for ordinances, we get them typically with the packet, which we now get nicely a week before. But I think maybe it's a good idea to get them to us a couple of weeks ahead of time, so we have ample time to look through the details. And if we know we're getting them separate from the package, I do it, but, it'd probably be easier for everyone to get them ahead of time and then work out any individual questions that are ranging from typographical errors to, do we have the proper statute referenced when we're incorporating it? If we do that ahead of time, it'll probably make things flow a little bit easier. So if we can target, what's reasonable? 14 days, 15 days before?
It could even be earlier, just depending on the
Perfect.
ordinance and the process, but
Excellent.
we'll ensure that council gets them certainly at least a week before the packet, collectively.
Right.
But we're going to aim for.
Right, and we understand that there may be a need for an emergency ordinance, and, that's just the way life goes, but great. Anything else for the town attorney? No?
Thank you, Mr. Mayor.
Yes, town manager.
Thank you, Mr. Mayor, council. Just generally regarding Florida City Gas and provision of their services, we have discussions regarding franchise agreements and easements and so on that are ongoing, and just don't have anything concrete, but we continue to work on that and have some meetings scheduled over the next month in that regard. Mr. Sweeney and I and staff internally have been looking at our land development code review, and then Mr. Sweeney and I had a fairly extensive meeting with one of our outside consultants that has been working on some consistency review, made great progress in the land development code, and hope in hopefully by April, just have at least some sort of prospective itinerary for where we're going to go with some of the items on there. You may see some come out just individually, things that we need to repeal or slightly amend, versus others that are more substantive that will want to have a more public workshop discussion, things like that, subject to the direction of council. So that's where we are in the ordinance review. Regarding the CRS and rate classification updates, right now I just want to mention a couple of things. Currently we're at our class 6 point, we're at 2,190 points. In order to get to a class 5, we have to be at 2,500 points. We have taken a substantial step in that direction at virtually no cost with our adoption, respectively, the DFE +2 ordinance, which will result in almost 600 points. We have a number of other items that we will be calendaring. A lot of these relate to both outreach. When I say outreach, really two forms of outreach. One, which would just be the passive receipt of things through our website, newsletter. But we also have a mailing scheduled to come up shortly on CRS, resiliency, and things like that will go out to everyone in town. And then there are some other items that are not delivered as such, but workshops, open houses, and things like that. So our goal, obviously, is to get to that class 5 to do two things really primarily. One is just the resilience for the town, structures, residents, And the second is to realize the benefits through the NFIP program by getting to Class 5 and have that inure to the residents. Regarding timing, we just continue to move forward and plan. In regards to the overall cost, a broad just estimate on some of these items, I think it would be less than $10,000 to the town to get us to, or in that area. Let me do it. See, Councilman Brother scratching that out immediately.
I'm applauding.
Just remember, it's not in stone, it's just ink. But nonetheless, that's kind of the goal, and we are moving forward. We do have our 5-year review cycle next year in 2024, so all of these things should hopefully culminate, at that point in time. So that's where we are on CRS. If there's no other questions on that, that's pretty much what I have this morning, unless there's any other general questions.
Anything for Mr. Hartbrain? Nope, thank you very much, and especially the early report on the CRS, because the one thing that makes constituents happy in this environment is when we do things that potentially lower their insurance rates. So, yes, sir. Thank you very much. We will now move to the council committee reports, and we can start with Councilmember Smith, and we'll work across the podium.
Okay, had a beach and shores preservation meeting, and nothing has changed as far as Sector 4. We're still have the documentation in there, and it's probably going to be months before we'll hear anything. So nothing to add there. The problems with the Sector 7, the area that has all the money but can't get the signatures, so they're almost out of time now. They only have 55 of 82, so they will most likely lose all that funding as of April 1st. Because the people in the area won't sign easements. And this big sargassum bloom that they're talking about, the big seaweed thing, Eric from this Beach and Shores said that, the news media is making it a bigger deal than it really is, but that they are watching it and they're watching the flow of it, and if it should happen to hit our shores, they're ready to take care of it and remove it. So we'll just, at least they're talking about it. And the only other thing was I did attend the CPR and the AED training, which was really, really good. I'm glad that, I can try to give CPR. I wasn't very good at it, so I kind of flunked. But I at least know that I can try to keep someone alive. And the AED training was really interesting. And I think that is really good for all of us because they have them everywhere. So it's kind of nice in case you're by yourself or you're on the golf course or you just happen to be anywhere that it happens that you know how to do that to help save a life. So I was glad I went. So
Mr. Mayor, real quickly, we're setting up another date to try to capture everyone. We've had 2 training dates for everyone in town. So we'll publicize that date to council if anybody on council wants to attend as well.
Terrific. Thank you. Thank you very much. Mr. Altieri? Nothing. All right. I have Treasure Coast Council of Local Governments and Regional League of Cities. On Regional League of Cities, Councilman Elwater attended the luncheon, which was at Marsh Landing, who's the name of the restaurant in Fellsmere. We had a legislative report that was provided by the League. In addition to the bill we talked about, there's a lot of other, let's call it interesting stuff floating around out there. In particular, a bill to basically prevent exclusive franchises for waste management in certain municipalities. And so, in other words, private contractors could come in and compete. Sounds like a good idea, but my limited knowledge on the subject is that it could greatly hamper the ability of municipalities and counties to negotiate rates that will stick in long-term relationships with contractors, because they would be subject to coming in and, notwithstanding a franchise agreement the town may have with XYZ company, Johns Island could decide that it wants to have its own private contractor. So it could lead to all sorts of mischief, adjustment in rates, and generally there's a fairly hot debate about it, and whether it moves forward or not still remains to be seen. There is we spoke about, all right, we spoke about the bill already on the change to potential partisan versus nonpartisan elections. One thing I forgot to mention on that is that apparently on the genesis of this was the school board. They were going to propose having partisan elections for school boards. That died in committee last year and the year before, I believe. And it mushroomed, as things do in the legislature now, into all municipal elections. Beyond that, I have nothing to add other than a request for my my backup to attend the May meeting, which I have a scheduled conflict for. If my backup can't make it, any other council member is welcome. And in fact, I think any council member is now welcome to attend the luncheons, not the business meetings. Generally, they have fairly nice luncheons. So town staff is also invited as well. So if you're interested, I'll put that out through the town manager. And that's all I have.
Nothing. I attended the Bike Advisory Committee, that's not the exact title, the MPO, and there was a discussion about the project to redo State Route 510 from Route 1 to 512, which is probably 5 or 6 years out. I mean, it's going to be beautiful. It's going to be 2 lanes in each direction. There's going to be a shared bike path, a shared bike and pedestrian path. There's going to be bike lanes. FDOT's doing a nice job. One interesting thing I found was when I asked this question about currently when you cross over 510, cross past US 1, you hit the train right away. And FEC has redone on that. And I said, well, what happens if we're, instead of 2 lanes going across, 1 in each direction, now you have a total of 4 lanes going across? Were we going to have any issues with them? The consultant brought up that, according to her, that FEC has then the right to try to pull 2 other lanes some other place in the county and not have that cross anymore, which was a complete shock to me. So I got to check and see if that is really accurate. She also made an interesting comment in that she sees that Brightline is now really interested in safety, and I pointed out to her, yes, Brightline's always interested in safety, as long as somebody else pays for it. Yeah. So, I mean, that's the thing that's going on there. Just one other thing for council. I don't know if the others do. If you listen to the Florida League of Cities morning call at 9 a.m. every Monday, there is the bill that is going to require enhanced financial disclosure. Basically, you're going to have to disclose everything if it's over a certain percentage or so. That seems like that bill is headed for passage. Everything I've heard is that the state representatives basically say, and state senators, I have to do that, why shouldn't you have to do it? So I think that's lost cause as opposed to the very limited disclosure that we have to do.
So that would change what we do?
Yes.
You'd have to do a
Form
law.
6 now, yes. I had to do it when I applied, when I ran for county commissioner. It's much more invasive, so.
All right, anything further from you, sir, or we're good?
No,
All right.
no, I can't think of that bad stuff.
Okay, great, thank you. Call to the audience. Mr. Korpar.
Yes, Mike Korpar, General Manager, Johns Island. Comments first is Republic has gotten a lot better. The community does wish they would work a little bit better on their communication. Last week on Wednesday, they completely missed the west side of Johns Island for recycle pickup. And then when calls for all the ensuing day, the lady was asking for addresses, like, oh, we missed you, we'll come get, no, you missed the whole west side. And lately their trucks, we've had now 3 separate incidents of, basically because they're using these new hydraulic trucks, of hydraulic lines breaking on their vehicles. We just had one yesterday where 2 residents' driveways were quite stained. They're trying to clean it up, but I don't know if the town has any influence on asking them to make sure your trucks are maintained a little bit better so they don't do this. The other thing which Mr. Jim Harpering mentioned on, Is there an end date on the town's franchise agreement to be done and signed? Just because now the community's getting a little excited about the gas coming in, people building homes are getting excited. It's all based, they want to run, we had a meeting with them, they want to run the lines within Johns Island this summer to not disturb, but they don't, our community doesn't want to do anything until the town has signed the franchise agreement.
And I'm sure they want to get it done before there's talk of banning gas stoves like they did in New York, right?
Yes.
So I'll let Mr. Harping speak to this, but we're working on the franchise agreement as we speak. We intend to have a call with council next week to work out some of the fine points, and full disclosure, that's really in the administrator's hands in the town, but what do you anticipate, a couple of weeks?
I don't want to put a date on it to either kill my own expectations or otherwise, but we've been talking about the franchise agreement. It will, of course, have to come up in front of council. The earliest date that would obviously be the April date, but a lot will be contingent on on actually a number of things we have scheduled for next week. It would be unfair for me to give you a date, but we will communicate that once we have a little better focus on where we are with the franchise agreement and when it will come up before council to review.
So a part of our job is to be unfair to him. So in my mind, I'm thinking, my target is 2 weeks to have everything with our lawyers worked out with, Florida City Gas now. We're only half the equation. So, we need a partner to dance with. If they're ready to go in 2 weeks, we'll be ready. But as Jim said, we all have to approve it, look at it, approve it at a council meeting. So the earliest would be April, but,
They've kind of tentatively told us, just so you know, for information purposes, pretty much once this gets signed, they anticipate having gas running in the community in the fall, with the exception of Gem Island and out on Coconut in those areas, just because they got to get FDOT or somebody's permit to go under the bridges. We have 2 bridges they have to go under, which so that's 2 years out for those areas.
And as an aside, it's not just the documentary franchise agreement. We're also concurrently working on the easement agreement, which will require Florida City Gas to put in a regulator station, just north of Town Hall here. And I don't know anything about that timing yet either, but we'll keep everything.
That's more complicated, so we're giving Pete 2 weeks and 1 day.
Okay, thank you. That's all I have.
Two questions. Have they given you any idea what the homeowners what the expenses will be for the individual homeowner?
They've not given us expectations. We asked them if they're going to be a certain amount they have to sign up for the service. Pretty much they've told us, John's on, they're going to run the lines in there as long as we give them approval, regardless of who signs up. Cost-wise, they'll run, they said to do all the infrastructure at, per se, no cost to anyone. But once they go from the road to your home, that'd be a cost on the homeowner, and they have not relayed that to us yet.
They haven't relayed that.
No, but they will. They said they're going to have companies. We plan on doing like a town hall meeting for Johns Island. They're going to have some companies lined up too that will convert your appliances if they're convertible, or an appliance company that can replace your appliances to meet the natural gas, things like that.
And then can I have one more question?
Absolutely, please.
Okay, so we were talking about the, Jim, the franchise for the land. So does that come under that ordinance where the public can participate in us using the private property rights that we were talking about with Jim? Like, could the public say, I don't want that there?
That's actually town property. I will defer to Pete on the nuances to that, but certainly we have an easement agreement up. If it's discussed in public, anybody could say, anything they want about it. But my lay opinion in my chair now would be that it wouldn't affect that, because that's town public property. It's not adverse to any public entity relative to a taking or an easement or anything like that. It's already ours.
Okay, thank you.
Mike, do they have a standard memorandum of understanding that they prevent for each community?
They have something, but they're not going to release that until the town signs the franchise agreement. But they do have standard one, yeah. Well, thank you.
Thank you. Anyone else? Going once? Going twice? All right, thank you everyone for your attention. We are adjourned.
Good job.